Good morning everyone and welcome to our latest webinar in which we're going to be simplifying family leave, and we're going to be talking about it from a practical perspective today. And it is a complex area of employment law and not necessarily the easiest to understand because of the many rules that we have for today. But we've selected the key areas of focus that we think are going to be the main ones that you'll be interested to understand a little bit more about. Obviously we just have an hour, but we can't go through everything in terms of all the family friendly rights, but please do follow up with us afterwards if you would like our help or clarity. So as usual, we'd like to introduce ourselves. I'm Victoria Templeton, HR Knowledge Manager at HR Solutions, and I'm joined by Sue Watson, who is our Operations Director. And together we're going to take you through the family leave and discuss what we recommend for managing it to make it as easy as possible. But just a few words from a housekeeping perspective. You are all going to receive a copy of today's slides. We're also going to be sending an email out after today's event where we'll provide you with the links to a recording of the webinar and any relevant links that will be of information to you, and then these will be sent to you in the coming days. So continuing with our housekeeping, because we've got so many of you today, we've placed you all on mute. However, as always, we do like your involvement in our webinars, and we'll do that by inviting you to ask us questions. So on the screen now, you'll see our image of what your go-to webinar question panel looks like. So simply add your question in as we go through the webinar, and then Sue and I will aim to read as many as we can at the end. And then another way in which we'll get you involved is through the use of polls. And you'll know that we're about to run one when you see this slide. So polls are really helpful not only to the running of our webinar, but actually we find that it helps everybody gain an idea of what other businesses are doing or what they're thinking on a particular subject. They are confidential. We just know obviously the numbers of how a question is voted on. And this is our agenda today, and we're going to begin by setting out the various forms of family leave, and that will be the basis for what we discuss. And then the second part and the bulk of the webinar is going to be talking about the law, but then actually talking through how to apply it in practice. The practical solutions that we're going to talk through not only help you to manage the complex area of law, but actually they're all steps that will help you to prevent risk in your business from a tribunal claim. We'll then summarise some of the key developments in the law that have happened this week, as well as consider what's coming up on the horizon. And then we'll finish off with our Q&A, where Sue and I shall take your questions. So please do keep your questions coming through. So first of all, I just want to clarify the sort of types of family leave that's available and which we'll come on to talk about. So there are many, many different forms of leave. We have the adoption and maternity leave protections. We've got new employment law that was implemented on the 6th of April, so just a few days ago, where people have the entitlement to up to 1 week of unpaid carers leave. We have parental leave that's available to employees, parental bereavement leave, and then you've got your paternity leave. Again, we've seen changes in that area on the 6th of April. And I'll highlight what those changes are towards the end of the webinar. And then we have shared parental leave and time off for dependents. So as you can see, there's a wide range of forms of family leave available. And as you'll see towards the end of the seminar, there's some other areas that are in the pipeline and we're expecting to see developments in. So I'm now going to sort of focus through managing family leave. So before talking about how we apply it, we're going to just understand at high level what the law says. And as I said at the start, because there's so many different areas to it, we can only deal with so many in the hour. So we've picked the key ones that we think will be of most of interest and helpful to everybody. So what we're going to look at is these areas here. So that will include the obligations for notifying the employer and an employer's obligations for responding when it comes to intentions to take one of the many forms of family leave. We'll look at health and safety, a really critical area of law. communication that can sometimes cause some confusion as to the amount of communication and what we can communicate on during periods of family leave. So I'm going to go through that. Contractual obligations, obviously that's fundamental because whilst you're supporting somebody on family leave, you need to also be conforming to your contractual obligations. I'm going to pick up as well on redundancy situations, particularly because the law around this has changed again in the last week. So I thought it would be a helpful opportunity to sort of touch on that area. And then towards the end, we'll look at the statutory leave entitlements and pay. And we'll talk through our suggestions about how you can make that as easy as possible for managing it in the business. But we've come to a poll slide, so it's really this early on, just want to ask a couple of quick polls of you all, and it's regarding your policies first of all. So do you tend to have individual policies for each of your forms of family leave, or do you have one central policy that has it all included in the one document covering them all? Or it may be you don't have policies. So let me know what your situation is.
Most people have voted now, so we will
Okay.
close that poll and I'll share the results with you.
Oh, interesting. Yeah. And I think, yeah, the one family leave policies, that's something that we have moved to in recent years, having it all in one place. And I think it makes it easier for the employee. As I said, it's family leave and entitlements aren't the easiest to get your head around or remember. So actually having it all in one place just helps it for the individual knowing where to go. But I think also having one policy, it's more inclusive. So rather than you as the employer giving the individual the relevant policy, assuming you think they need that one, actually, if you have that one policy, it's for the employee to decide which part of that policy they want to read. You know, so it's about being more inclusive because we have more of a diverse workforce. Obviously, 43% of you with individual policies, that's good to see. And generally, pretty much all of you have got policies, which is good. And that's the important thing because they are fundamental to managing family leave, helping your managers to navigate through it, but also critically fundamental in preventing tribunal claims. So thank you for that. And then we've got one final poll before we move on. And it's more about which of the areas do you think are the most challenging to manage?
There you go.
Thank you.
Okay, we will close and share that poll.
Yeah, so interestingly then, redundant situations, and I can understand why that is perhaps one of the more challenging areas. It's not an easy subject to manage any time, but obviously it becomes a little bit more sensitive and complicated, if you like, when individuals affected of redundancy and on family leave. But we'll come on to that, and hopefully what we cover will help you in that area. And then obviously notification and acknowledgement. Yes, there's a lot of admin, isn't there, to managing family leave, and it's crucial that it's right because there are some legal obligations in regards to that area.
Absolutely.
Yeah, and communication. Yeah, so all of these we're going to cover. So hopefully what we talk about and just the suggestions we've got will help for you to take some ideas away. And yes, by all means, ask any questions as we go through. So thank you.
Thank you.
And we're going to start with the whole piece around notification and of intention to take leave, and as well as the requirement to respond. So we've got a couple of slides. So the first one is focusing on the adoption leave, carers leave, maternity and parental leave. So what I think makes this probably a difficult area to manage or challenging is that there's so many dates, so many time frames for each different form of leave. And so it's almost like we need one sheet, don't we, with just the key pointers on. But essentially, adoption leave, you've got a defined period of time that the employer has to notify you by of their intentions to take it, and then you as the employer have so many days in order to acknowledge their notification and confirm the date the leave is going to come to an end based on the information they've given you. With carers leave, that's our new legislation. We'll talk a little bit more later on, but essentially it's about giving twice as many days as the number of days requested. If the leave requested is more than 3 days, if it's longer than that, then it's 3 days notice. Now, when it comes to employers' responsibilities, in terms of the whole notification and responding, you can't refuse, but you can require postponement, and there's some legal timeframes in that, and that's where you have to write within 7 days of the request with a new proposed date. So as I said, we'll come on to that a little bit later. Your maternity leave, the employee has an obligation to let you know of their intentions to take it, and that's by the end of the 15th week. It's entirely up to them when they notify you of their pregnancy. Typically, I think most people tend to notify as soon as they've got past that initial first few weeks, and when they've got the perhaps MAP-B1. But actually, it's the employee, it's entirely up to them when they notify you, but it must be by no later than the end of the 15 weeks. Then the employer, you have obligations as well. You must be confirming to them within 28 days from receiving the notification that you've received it, and that they'll be going on maternity leave, and be confirming the date that the maternity leave will come to an end. And then parental leave, employees as well have obligations still, and this is at least 21 days notice of intention to take it. Employers can postpone it, and again it must be within 7 days of receipt of the request, but the new date proposed no later than 6 months from the original requested date. So there are a couple of elements of flexibility for employers in regards to the taking of carers leave and parental leave, but there are still timeframes in which you need to manage that flexibility. And then this slide is dealing with your parental bereavement leave, paternity, shared parental leave, time off for dependents. And so the parental bereavement leave is where you need at least 1 week's notice after the initial period, but obviously you can't expect to have it immediately following the passing of a child. The paternity leave, notice of entitlement is by the 15th week for the EWC, or no more than 7 days after the date on which they're notified if they're adopting a child. But what we've now seen, because there's been developments in the law on paternity leave, is that yes, they have to give you the notice of their entitlement by the 15th week for the EWC, but the way paternity leave is now managed, because there's more flexibility, there needs to be at least 28 days notice before the dates upon which they intend to take each period of paternity leave, because there can now be different periods of which they can take it. Shared parental leave, this is a very complicated area of family leave, and I think there are plans for reforms to it, and actually I don't know in practice how often it is used, but essentially it's about splitting the maternity and adoption leave and allowing both parties to be able to take a period of that leave. So the notice of entitlement and intention to shared parental leave is no less than 8 weeks before the start date, or at least 8 weeks before they wish to bring the adoption leave to an end in the situation of an adoption. As I said, that's a complicated area, probably not one to go into detail in our webinar today, but nevertheless you need to be aware of the notification requirements. And then time off for dependents. This is an interesting one in that it technically is about how you allow people time off from work unpaid in order to deal with an emergency situation that involves a dependent. So if somebody is coming to you and saying, I need next week off because of XYZ, clearly that's not an emergency and it wouldn't be time off for dependents. So the right is all about having that time off in response to an unexpected or sudden event where you need to either provide that, make that that time off to care for that dependent, or make arrangements for the long-term care. If the problem, like I said, was reasonably foreseeable, then it's unlikely to be entitled to this type of leave. So it is an interesting one, and it is, as I said, one for emergency situations. So when it comes to the practical side of how you can effectively manage all of these different timeframes, notification requirements, responses, well, really, it's about ensuring your policy, first of all, sets out the employee and employer responsibilities and clearly communicates the timescales for these within that document, and make sure that all your employees know where to find your family leave policy or individual policies. Introducing checklists are really, really valuable in managing family leave because I think because family leave isn't a regular occurrence, generally, it might come up, you know, very infrequent or sporadic. And so to help line managers deal with it when a new request comes in, then having that checklist will be that comfort blanket, if you like, to know that they are doing all the things that they need to do. And having a checklist makes sure that your managers are adhering to ultimately the legislation and therefore reduce the risk of claims. We would always as well recommend having template letters in place to deal with your maternity leaves, your adoption leaves, parental leave. It ensures consistency in how you're communicating with your employees, but it also helps, again, for you to remain compliant with the law, because you know that if you've got your template letters established and they're conforming to the regulations and best practice, then you know that you're going to be, again, mitigating any risk from tribunal. And training your line managers is also vital in supporting and managing people when they're taking a period of family leave, because ultimately they're at the heart of managing that process and pivotal in preventing any tribunal claims, you know, so ensuring that they're able to manage effectively the whole process. And as we'll go through the webinar, you'll start to sort of identify the responsibilities that line managers have during periods of family leave. Health and safety. So this came up as one of the main areas that is a challenge for employers. And so if we look at what the law says, well, there's an obligation on all employers to protect the health and safety of their employees and anyone else who may be affected by the undertaking. So the obligations do also include the protection of the health and safety of your employee's unborn child as well. And this is where the management of health and safety at work regulations kick in, because there are requirements to assess the workplace risks that are posed to new or expectant mothers or their babies. There's an obligation to alter an employee's working conditions or hours of work to avoid significant risk. There's an obligation on employees to offer suitable alternative work, which is an obligation under the Management of Health and Safety at Work regulations and within the Employment Rights Act of '96. And there's also an obligation for employers in the situation of actually carrying out a paid suspension on maternity grounds, which again is another obligation that's in both regulations, the Management of Health and Safety at Work regs, but also the Employment Rights Act of '96. So that's the legal framework in which we have to manage health and safety. And I'm just going to take you through how we can apply that framework in practice. And the starting position is your risk assessment. So complete a risk assessment as soon as you are aware of the pregnancy. But what's also important is that you review it throughout the pregnancy. It's vital that it remains under constant review, because as the pregnancy progresses, health needs of the employee can also change, which may trigger the need for further adaptations. So what you also need to be mindful of is risk assessments should also include and consider how you manage risks for those employees who breastfeed or are expressing. So it's a really key tool. So as part of that whole risk assessment process, there's a requirement on employees to record findings and review those risks. So make sure you capture that from the process, and if you haven't verbally discussed your findings with your employee, then you are obliged to be providing them with the written details of them. As part of that risk assessment process, and you've identified any steps that you need to take, and it's about then working out what would be a reasonable adjustment to accommodate their needs and support their health and safety. So it could be reasonable adjustments that are made to their job role. It could be the hours of work, where they work, any equipment that they currently use for their job. You may need to look at that, or the working environment. So if we think about the working environment, it might be temperature. So it may be that you need to implement a desk fan, for example, or it could be the equipment they rely on. So their chair, they might need a different chair or support for their lower back. You know, it's just thinking through the practical steps that you can take to remove and reduce, lower those risks that have been identified. And then moving on, there's a piece around medical advice as well, because it's important to understand that as line managers, yes, we can take steps to manage their health and safety in the workplace on the back of the risk assessment, and think of some practical ways in which you can support them. But there may be times when the health issues are such that you actually need expert medical opinion on that. So you need to seek external advice, whether you have an occupational health process in place, or you need to liaise and get medical guidance from a midwife or their GP. So be mindful that there may be occasions where you need to seek that medical advice about the individual to help support them during their pregnancy, or on their return to work. In terms of antenatal appointments, then clearly your employee needs to take time out of the workplace to attend antenatal appointments. Time out must be paid. Any refusal to allow the time off and any detriment for having taken time off could lead to unlawful discrimination under the Equality Act. Some employees may require additional medical care, either to support an existing medical condition during the pregnancy, or perhaps their pregnancy may bring about new health issues. So just be mindful that yes, apart from the antenatal appointments, there may be a requirement to allow them that time out to attend other medical appointments for their health. So suitable alternative work, on the back of the risk assessment, then if you can't bring practical steps about through equipment, etc., then you need to consider what other job or work can they do. So this is if you can't amend their working conditions, their hours, or if the risk cannot be avoided, then you must offer them suitable alternative work where it's available. Suitable alternative work has to be appropriate for them to do, and that the terms and conditions are not substantially less favourable to their current terms. But there can be occasions, and I don't know if any of you have experienced this in your workplace, but there can be occasions where there is a need to suspend on maternity grounds. And that's really the last course of action. It's in the instance of not being able to offer suitable alternative work, or if the employee refuses for reasonable grounds any work, then you've got the option of suspending on full pay. So there could be a medical need to suspend once all reasonable adjustments have been exhausted, yet there remains a significant risk to the health and well-being of the employee and or their unborn child. So that is something that should be considered, but as I said, it's probably rare or not that necessarily a common thing, because risks can generally on the whole be managed through either your adaptations or being able to provide some alternative work. So what we would also suggest in terms of this area is ensure you have risk assessment templates available for your managers to use that obviously deal with pregnancies, return to works of new mothers, employees who are breastfeeding. Educate your managers on how to carry out the risk assessments and ensure your health and safety policy sets out your approach to supporting employees who are pregnant, returning from maternity leave and who may be breastfeeding. We would always advise keeping records of your discussions that you have with your employee when you're trying to implement reasonable adjustments or where you're exploring suitable alternative work, or even if you're in the position of needing to suspend. And suspension on maternity grounds, as I said a moment ago, should be the last option that's available to you. And if you are in the situation of needing to carry out a paid suspension, then obviously it's important to handle it sensitively and confirmed in writing. Next, we're going to look at the communication, and this came up high on our poll a moment ago. I think 43% of you identified this being a particular tricky area. And I think if I was to say out of sight, out of mind, this is perhaps a statement that unfortunately can easily be felt by employees who take time out of their careers to raise a family. And it is often unintentional on the part of the employer, but nevertheless, this out of sight, out of mind, you know, it's can lead to legal challenges and implications in respect of failing to reasonably keep in touch. So just wanted to sort of talk through now what the law actually says. And I think it was about probably around 2007 the law was changed to address concerns because current laws at that time did not do enough to encourage effective communication between both parties when on a period of family leave. And specifically it was the focus around the adoption of maternity leave. And as I said, the phrase out of sight, out of mind is one that probably many people can feel, unfortunately. And as I said, it's not necessarily intentional on the part of the employer, but so it's about trying to make sure your working practices prevent that. And we'll go through some of those in a moment. But going back to what the law says, the maternity and parental leave regulations were updated to include an explicit provision for reasonable contact and a statutory right for keeping in touch, having keeping in touch days. And what the legislation introduced when it came to reasonable contact, it defined it as reasonable contact from time to time between an employee and her employer, which either party is entitled to make during a maternity leave period. So that's what was introduced, and that gave a lot of confidence to employers to know that they could contact somebody when on a period of maternity leave. And then obviously we then had the introduction of kit days, so they've been around for some time, but it enables the employee to carry out work without bringing the leave to an end. So when it comes to applying it in the law in practice, this is probably, I don't know, I think perhaps one of the hardest ones and difficult, but these are what we would think as reasonable approaches to do it. So really the most important thing is to agree your approach before the period of leave starts. Don't leave it until let them go off and then think, oh, how am I going to communicate? Really, as part of your maternity adoption processes and your checklist that you have, there should be a task there that requires you to sit down with the individual before they go off on their leave for you to then both agree a approach for how you're going to keep in touch. So, you know, you could find out before how much contact they would like. how would they like the contact to be made, and on what business matters would they like that contact to be about. And then we would also say include them on your distribution lists for workplace news, social events, training courses, unless they request otherwise. Because this is where the outside out mind comes in, because you might be organising a summer party. If you exclude people that are out on maternity adoption leave, that's where you're exposing the business to risk of unlawful treatment and discrimination, because you're excluding them. So it's really, really important that they're involved and included. They're absolutely entitled to not take up on any offer or to pursue any action that will be within that communication, but it's about making sure that they at least know and are informed. When we think about reasonable contact, then unless they specifically request otherwise, then it's about providing updates on important developments at work. It's really vital to inform them of any promotional opportunities or vacancies. Don't assume that just because they're out, and we expect them to be out for 1 year, that they're not going to want to consider a promotional opportunity, say 8 months into their maternity or adoption leave, just because they're out. You never know people's circumstances, how they're feeling, what their approach is at that moment in time and their circumstances. Don't assume that just because they've got a few more months left that they're not going to want to take any new vacancy or job opportunity. And then reasonable contact can be used to discuss return to work arrangements. We then have your kit and split days. So the shared parental leave is all your split days, your kit days, obviously maternity adoption. And so that's about keeping in touch, communicating where they're coming into work to carry out work, and without it bringing the leave to an end. And they can use those kit days for attending team meetings, attending business updates, to carry out training, or it can be used towards the end of the leave period to create that flexible phased return to help them come back gradually. In terms of pay, then it's a matter for the employer and the employee. Generally, it is the normal contractual pay that's given when somebody comes in and carries out the pay. And then redundancy, and we'll come on to this a little bit more, but redundancy in terms of communication, it's really, really critical here, because employees must be informed of the proposed business changes because it's significant. So you need to communicate to your employees who are on a period of family leave. We would always say seek advice on how to manage particular redundancy situations where there are employees involved who are on family leave or who are about to go on family leave, because it's working out the most appropriate way forward. But the important thing to highlight here, and what we'll cover a little bit more, is around if somebody is dismissed on the grounds of redundancy and they're on maternity, adoption, shared parental leave, or they are pregnant, then they must be offered suitable alternative employment over other employees. Even if other employees are more qualified, the employee who's protected under those family leave reasons must be given the suitable alternative role over others. And we'll come into a little bit more shortly on that. So when it comes to applying it, the law in practice, then just remember, avoid out of sight, out of mind. They should be part and parcel of, if there's a change going on in the business, think who is out of work at the moment that we need to inform and update on. Meet with the employee before the leave starts and agree, as I said, the frequency of contact, method, and what information is going to be communicated. And then let them know that even though they'll receive updates, invites to training even, or notification of vacancies, there is no obligation on their part to respond and to act. But you have at least shared it with them, and it's for them to make that judgment as to whether they ignore it or actually I'm going to consider and follow up. And then, as with anything, keep a record of what you agree, and that's where you can incorporate that step into your checklists. And then importantly, set Outlook reminders throughout the leave period to ensure you're maintaining your agreed communications. Now, when it comes to contractual obligations, again, this scored quite highly in our polls. And what we know from the law and the legislation is that throughout all the various forms of family leave, the contract of employment obviously continues. When we look specifically at adoption and maternity leave, then the employee continues to benefit from all of the terms and conditions that would have applied had they been at work, except for remuneration, and that's defined as wages or salary. And that's because they then, instead of having remuneration, they are receiving, where eligible, statutory maternity or statutory adoption pay. So in terms of the contract and the benefits, they continue to operate, they continue to accrue holiday. We have got some new changes to how you manage accrual rates for those who work irregular hours, who go on to a period of family leave. And even when it comes to company cars, if it's issued for if they've got a company car for personal use, then obviously that's where it can continue. But where it's obviously job purposes, there's no need for them to do it because they're not working. And then they obviously can continue to get all the other benefits that you offer, such as insurance schemes and things. From the employee's perspective, they are bound by the implied obligation of good faith and in any express terms and conditions of their contract. So that relates to notice provisions by the employee, the disclosure of confidential information, acceptance of gifts or other benefits, or their participation in any other business. So they still have obligations on their side of the contract. And when it comes to returning to work after adoption or maternity leave, then depending at what point in time they return, depends on what rights they have to the role that they come back to. So ordinary adoption and maternity leave is your first 26 weeks. And so if they're coming back to work only having just taken ordinary adoption and maternity leave, then their entitlement is to return to the same job. If they come back during or at the end of the additional adoption maternity leave, so the latter 26 weeks, they've got the right to return to the same job unless it's not reasonably practicable. And in that event, then any alternative role must be suitable and appropriate and on terms no less favourable than those which would have applied had they not been absent. So when it comes to applying the law in practice, then a few things that we would advise. First of all, we advise making policies non-contractual. That not only minimises the risk of breach of contract claims, but it also makes it easier for you as the business to change policies as and when you need them to be changed. Where you offer benefits such as bonus schemes, performance-related pay and other financial schemes, just make sure you've got clearly well-written, non-ambiguous written rules explaining the schemes and making it absolutely clear that they're discretional even. It is a complex area of employment law. Nothing is clear-cut. There'll always be grey areas. So if you get queries that are of a contract nature, then seek advice if you're unsure on how the query impacts on the contract of employment. And then redundancy situations. This came up as the top most challenging issue for managing family leave, and this is an area that has literally just changed. Employment law has just changed the 6th of April. So what the law says now is those employees on adoption, maternity, shared parental leave and those who are pregnant have a legal protection, like I said a moment ago, to have to be given a suitable alternative role in preference to other employees if they're made redundant. And it includes employees, so the changes this week have included employees who are pregnant. The protection period for how long somebody has that protection has been extended, and I'll come on to that in a moment. And the protection also, not only when somebody is pregnant, but in the unfortunate situation of somebody that suffers a miscarriage or stillbirth, then there's a period of protection as well. in those situations. So the next slide hopefully will make it as clear as possible. And so, as I said earlier, slides will be sent out to everybody afterwards. So depending on the type of leave will determine the length of protection and from what point in time it commences. So as you can see in the first box, it's all about the adoption leave, and it starts as soon as somebody begins their adoption leave. And its protection lasts for 18 months from the date of the placement, or if they're adopting from overseas, then it's 18 months from the date of entry into Great Britain. When your employees are pregnant and taking maternity leave, the period of protection begins when the employer is notified of the pregnancy, and then it ends 18 months from the child's date of birth, so long as that was notified before the end of maternity leave, or 18 months from the EWC if that hadn't been notified. When you're in a situation of you've got a pregnant employee and they suffer a miscarriage, then the protection, for when they're pregnant starts when you are notified of their pregnancy, and it lasts for up to 2 weeks then after the miscarriage, when that occurs before 24 weeks of pregnancy. Now, if the situation was to occur after 24 weeks of pregnancy, it's not deemed as a miscarriage, it's stillbirth, and you'll know from existing maternity rules that when somebody has a child early, so any time from 24 weeks, then maternity leave commences. So in this situation, the protection period began when you were notified of the pregnancy, and you then move into the rules for as if they've taken a period of maternity leave, so the second box along. And then when it comes to taking shared parental leave, and the employee hasn't taken adoption or maternity leave, so the partner, so it begins at the start of the shared parental leave, and it ends at the end of the shared parental leave when less than 6 weeks are taken, or it ends 18 months from the child's date of birth when more than 6 consecutive shared parental leave weeks have been taken. So I appreciate there's a lot of information, differing days, timeframes, hence why it's really important to have things like your checklists in place for all the different forms of family leave. So when it comes to applying the law in this area, we would say that if you're planning a redundancy programme, it's really important that you identify all those who may be entitled to greater protection should their role be made redundant, because if you fail to give them a suitable alternative role and they're made redundant, then that dismissal will be on discrimination grounds and it'll be unfair. It's really important that you have all the key dates relating to the adoption and the birth, and like I mentioned a moment ago, introduce that checklist to support you in the running of your redundancy project, to help you take steps in order that they're needed, but also, and importantly, maintain legal compliance. What's also really important is to monitor all vacancies across the business throughout the redundancy programme. Ensure that you establish early on which roles are likely to be considered a suitable alternative as opposed to just a different role. And then we're coming on to statutory leave and pay. And the next slides really are just a table just to summarise. So technically, when it comes to your adoption, maternity and shared parental leave, so statutory pays for weeks 1 to 6 and then changes from week 7 to 39, and it depends, as you can see to the right here, it's 90% of average weekly earnings, and then the latter period, weeks 7 to 39, is either 184.03, that recently changed, per week, or 90% of the average weekly earnings, whichever is the lower. And the average weekly lower earnings limit, is the £123. Paternity parental bereavement is statutory pay for 2 weeks, and again statutory pay is your £184.03. And as I said, the lower earnings limit. So that's the minimum level of earnings an employee needs to qualify for benefits and when you calculate family leave payments. So this table is just highlighting the various entitlements in terms of length of leave, whether it's paid from a statutory point of view or unpaid, and then what qualifying service people need. And I think what I said at the outset of the webinar, this is it can be a confusing area of employment law when you're managing and supporting people on family leave, just simply because there are so many different qualifying services, lengths of leave, how pay is managed. Some get pay, some are unpaid, and so it can be really hard to keep on top. But here's a summary, and as you can see, it all varies. You'll see in here the carers leave, which is new. That's an unpaid right from day one, and we've had a change now to paternity leave in terms of how you can manage it. So the many different suggestions that we've sort of gone through so far are all things that will help prevent tribunals from occurring. If you were to be in a situation of faced with a tribunal claim, whether it's in respect of discrimination on the grounds of pregnancy, paternity, sex discrimination, or any of the others, or unfair dismissal, these are the amounts. They've been updated in April in line with the annual rate increases. So where you've got, for example, a breach of contract, say you didn't manage the family leave in line with the employee's entitlements under their contract of employment, non-compliance with contractual terms, breach of contract can lead to claims of up to a maximum cap of 25,000. Discrimination claims are unlimited. It comes down to the nature and the extent of the discrimination, and that's why we've got those vento bands. You've got a lower, middle and upper. They're increased every year, and those figures to the right are what have recently been introduced. So for like one-off incidences, they tend to put that in the lower band, the more significant and extreme obviously in the top upper band. However, there can be exceptional cases that give rise to a tribunal awarding more than that upper band limit of 58,700. So these are just the latest statutory figures. So it's really important to have your policies in place, line managers trained, and obviously your line managers carrying out all their obligations. So when it comes to applying the law in respect of statutory rates, then have perhaps flowcharts for how you manage leave and pay. There are government calculators available online for determining pay. Make sure you have template letters again in place to ensure employees are clearly informed of their entitlements, how much leave they're entitled to, how much pay they're entitled to. If they're not entitled to statutory payments, then things like your maternity allowance, and then also perhaps introduce an employee guide that provides all the key information in one document that's really user friendly, that the employee can keep, and it gives them all the key information that they need to help understand their rights at work. And then as we come towards the end, before we take questions, I'm just going to quickly run through recent and forthcoming changes. So it's been a big week in employment law. I'm sure you've all been aware of what the changes are. When it comes to family leave in particular, we've seen changes to how paternity leave is managed, and we've got the new carers leave in place. And then we'll also have some new laws coming in probably later next year. But the paternity leave regulations apply to all those where the EWC is after the 6th of April, or in the case of adoption, it's where the date of placement or entry to the UK is expected on or after the 6th of April. Now it means under the new rules that employees can take them either as a 1 week block or as a 1 week block of two, or one block of 2 consecutive weeks, or you can take 2 1 week blocks. So basically, employees are now able to take them in a more flexible way, and now have up until 52 weeks after the child's birth or adoption to take those weeks. And the notice period, as I mentioned on one of the earlier slides, the notice of entitlement must be by the 15th week, but when they want to take their periods of leave, then it's the 28 days notice that they need. The Carers Leave Act that came into force on the 6th of April, then it's a day one right, and it gives employees up to 1 week of unpaid time off to provide or arrange care for a dependent who has a long-term care need. The definition of a dependent is the same as that's used in the time off for dependency leave regulations, and employers can't refuse the leave, but they can postpone it, and that's where as an employer you must state in writing within 7 days from when you receive the request, and that the new date that you're proposing is within 1 month of the original date. And employees cannot be penalised for taking advantage of carers' leave, and a dismissal connected to the taking of it will automatically be unfair. That means they won't need the 2 years qualifying service. And then neonatal care leave and pay. It was passed as a piece of law last year, and it actually probably isn't going to come in until next year, perhaps early next year, and it's going to be a day one right. And it's essentially to provide neonatal care where an employee's baby needs to receive neonatal care in when they're born premature, if they're sick or they have a low birth weight. And the eligibility for the leave will be where the parent of a baby or babies are admitted into hospital as a neonate. The admission lasts for a continuous period of 7 days, and it's going to apply to someone with a parental or other personal relationship with a child that's to receive or has received neonatal care. And the total amount of leave is going to be capped at 12 weeks, and it will be they can take it in blocks of 1 or more weeks. So as I said, it is a law, it's just not in force yet, but we expect it to come into force early next year. So now's the time for questions. So Sue, just wondered, do we have any?
Excuse me. Yes, we've had a couple.
Okay.
I'm just putting them in the right order. So the first one is around returning from maternity leave. So someone's returned to work, but he's still breastfeeding. What is an employer supposed to provide and not provide? What don't they have to provide in this situation?
So you need to provide a suitable area, first of all, where they can rest. And that area that you need to make available in your workplace needs to be somewhere where the employee can lie down if necessary. It needs to be hygienic and in private, obviously, so that they can express milk if they choose. And things like requiring them to use toilets, clearly not suitable place for this. It needs to be somewhere private, hygienic, and include somewhere as well for them to store their milk, so to have a fridge available. Like I mentioned early on in the webinar, as part of the risk assessment process, employees need to assess the risks to employees, including those who are breastfeeding, and to do what is reasonably practicable in order to control those risks under the regulations. So there could be some areas of the type of work that may lead to greater risk for breastfeeding mothers and their children. So it depends on the type of work that they do. So you just really need to understand the risks in the context of your own workplace, and they remain, and the risk assessment remains in place for the duration as long as they're breastfeeding.
Thank you. And then another question related to maternity leave, but the cover for it. So when somebody's provided a fixed term contract to cover for maternity leave, and then the employee that was on maternity leave decides to come back early, what happens then?
Right. So this is where you need to have a contract that's issued to your replacement cover that's got the flexibility within it, because having the flexibility in the contract in the first place will make it easier to manage that situation, because essentially they're only, employed while somebody is off on maternity leave, and that employment comes to an end when that person comes back. So it's about the importance of having a contract that builds that flexibility in. And then also things like consider other vacancies that you have in the organisation that perhaps could be available for them. And you also need to be mindful of handover periods as well. So making sure that when the employee comes back from their period of leave, adoption or maternity, that they've got that time with the person that has been covering their role, so they're fully up to speed.
Brilliant, thank you. And we have one final question I think we've just got time for. If all maternity appointments need to be approved and paid, can we ask that these be used from the employee's annual leave if they have used all their paid sickness leave? So I think, just for clarity, a maternity appointment shouldn't be classed as sickness leave.
No.
And time off should be allowed for those. Paid time off should be allowed for it. So I would say no, you can't use them. You shouldn't require them to use annual leave or any other kind of leave. Is that right?
Yeah. So your antenatal appointments are a standalone statutory right, alongside your right to statutory holiday, and are also separate to sickness absence. So it doesn't get recorded as sickness. It's simply time out of the workplace. They're paid, and it's allowing them to attend their appointments with their midwife. They should not be using their holiday for those appointments.
I think it's if sometimes they want to attend some classes or that are in addition, not medical appointments or checks. I think that could be looked at slightly differently, I think, but again, it would need to be with caution, I think. Because that there could be potential for discrimination if you're not careful. There are a couple more questions. Shall we continue? Somebody was asking when the parental bereavement leave was introduced. Is that recent? That was last year, was it?
Oh no, not 5 years. No, it wasn't last year. Was it pre-pandemic or after? Pre-pandemic, I want to say.
Yeah, that was quite a while ago, wasn't it?
Yeah, pre-pandemic. That's my gauge in my head when I think about things. Was it before or after?
Yes.
So I think it was pre-pandemic.
And there's a couple of other quick ones. How should an employee advise us they are pregnant, verbally or in writing? I would suggest verbally initially, to start the process, but you definitely need to confirm it back to them in writing. So as a minimum, confirm the discussions, but usually they're right to you to tell them and attach their MAP B1 at the appropriate point as a minimum. So, but you could develop a form maybe that somebody notifies you so that you get all the details you need. And then on antenatal appointments, is there a right for paid time off for the partner?
Oh, something like 6 hours.
There's a restriction, isn't it? I think it is 6 hours.
It's limited.
So there is a right. But all of those details, if you want more details on the specifics for those policies, then we can just contact us. We can point you in the right direction. I think that's all the questions.
Brilliant, thank you. So just to last few remaining slides, we do offer an HR knowledge base. So I've talked a lot about checklists and letters, and actually we have a lot on our HR knowledge base. So if you need some resource where you in a standalone role, perhaps you need that help, then we provide lots of template documents and policies and articles covering the whole employee life cycle on our HR knowledge base. So there's a link there, so do take contact us if you're interested in finding out a little bit more about that. And then if you're looking for training of your line managers, we offer lots and lots in terms of all the different areas of the employee life cycle. And we also include ILM training as well, level 3 and level 5. So do, there's a QR code there, and do get in touch if you're interested in any training from us. For those of you who are regular on our webinar or new to our webinars, then this is our latest schedule for the coming few months. So next month is all going to be looking at those new flexible working entitlements, as well as the new law that's going to be coming in around the predictable terms conditions. So that's a real big development. So we'll be covering that on the 9th of May. June is about prioritising employee well-being, and then in July we're going to be talking about how to protect employees from harassment, because the law is going to be changing on that in September. We also have coming soon a strategic HR thinking white paper that's all about how to align people and business strategy. As you can see from the slide here, these are the areas that we look at, and we've researched and we've written our white paper on all these different current thinking around HR and the people strategy. We have one final poll. That's really if you'd like us to follow up with you after today's webinar about any of our services, whether HR services, training, payroll, the knowledge base, or health and safety. So do let us know, and then we can follow up with you.
Okay, I've closed that poll.
Lovely, thank you. And that brings us to the end of this month's webinar. So thank you everybody for joining us. We hope to see you in our future webinars. Thank you, Sue, for co-hosting, and we hope everybody has a good day. So take care, everybody. Thank you.